Hello and welcome to the BRR Legal Brief, where we bring you the latest legal issues affecting corporate Australia. I'm Kate Ritchie and today we're talking Fortescue after the High Court found in favour of Fortescue and Mr Forrest last week, effectively clearing them of breaches of the Corporations Act. Joining me to discuss the case and whether there are any implications for continuous disclosure obligations is Jeff Mansfield, who's a partner at Addison's. Thank you for joining me.
Thanks, Kate.
Well, before we look at whether there are implications for continuous disclosure here, can you give us a brief background to the High Court decision?
So let me set out the facts, what the ASIC allegations were and what the trial judge and the full federal court found first before we get to the High Court. So in August and November 2004, about 8 years ago, the Fortescue put out announcements to the ASX, and these announcements dealt with a statement that they'd entered into binding contracts to build and transfer a mine, a port and a railway, and these were going to be constructed by Chinese companies. The contracts were executed in China under Chinese official signing ceremonies, and the trial judge found that both Fortescue and the Chinese companies intended to enter into binding obligations. The trial judge also found that the Chinese companies had approved, or at least didn't disapprove, that Fortescue issue the announcements. So just a bit more about the contracts, excuse me. So the contracts were stated to be framework agreements. Sorry about this.
No, that's okay.
And they were subject to conditions and were stated to be binding once the boards approved them. They also provided that that additional agreements would need to be entered into to provide for detailed matters like the scope of works, the engineering drawings and like the pricing. So, but in March 2005, the Australian Financial Review put out an article that said that the contracts did not bind or force the Chinese companies to build, finance and transfer the port, the rail and the mine. So about a year later, in 2006, the ASIC took action against Fortescue and Mr Forrest, who was the chairman, CEO and a major shareholder in Fortescue at the time. And they alleged that the announcements were misleading and deceptive, that Fortescue had breached their continuous disclosure obligations by not updating the market with the correct facts, that Mr Forrest had been involved in the contravention, and that Mr Forrest had breached his statutory duty of due care to the company because he put the company in the position where the company was exposed to potential pecuniary penalties. So the trial judge at the trial found in favour of Fortescue and Mr Forrest. And he did this on the basis that the announcements were merely statements of opinion of what the board of Fortescue thought and believed the contracts to say. And the trial judge held that this statement of opinion was honestly and reasonably held. So he held that the announcement were not misleading and deceptive. So when it got to the full federal court, the three judges of the full federal court took a different view and held in favour of ASIC. And those judges held that, one, the announcement was misleading and deceptive, two, that Fortescue had breached its continuous disclosure obligations, three, that Mr Forrest had been involved in those contraventions, and four, that Mr Forrest had breached his statutory duty of due care. So a complete win in the full federal court by the ASIC. And they came to that view on the basis that the announcements, an public, the investors reading the announcement, would read that announcement to say that the contracts were legally enforceable obligations on the contracts to build and transfer the mine, the rail and the port. And they, having said that that's what the announcements were implying, the court then analysed whether the contracts were legally enforceable under Australian law. And they came to the conclusion that they weren't legally enforceable under Australian law. Therefore, they concluded that the announcements were misleading and deceptive.
Well, obviously that's a different opinion to what the High Court had. Could you run us through the High Court and what some of the issues that they considered?
Well, the High Court, in a five judges of the High Court considered the matter.
Yep.
And the 5 judges of the High Court came to the view that the full federal court was wrong, and they held in favour of Fortescue and Mr. Forrest. 4 judges of the High Court gave a joint judgment, which has really criticised the full court decision. They took a different tack to both the trial judge and the full federal court. In fact, the conclusion was, from the High Court, is that the announcements correctly summarised the contracts and did nothing more. On the question of legal enforceability, the full federal court had determined that the announcements dealt with enforceability of the contracts, and because they weren't enforceable, therefore it was misleading and deceptive. The High Court said that it would be extreme and fanciful for investors to come to the view that the announcements dealt with the issue of legal enforceability. And clearly, what they were saying, it was that a view adopted by the full federal court was extreme and fanciful.
Yeah.
And they analysed one particular issue here. The full federal court, the High Court said, had assumed that the contracts were to be interpreted under Australian law. In other words, they were legally enforceable or not legally enforceable under Australian law. But the High Court said that it may not be that Australian law is the proper law of the contract. The contracts did not have a choice of law clause in them at all. The contracts were entered into by Chinese companies in China. These Chinese companies were state-owned enterprises.
Yeah.
And so the High Court said it could conceivably be the case that the proper law, when you analysed it, was Chinese law, not Australian law. So they said that even if they were, even if the question of legal enforceability came up, the full federal court got it wrong in assuming that Australian law was the proper law to analyse it under.
Well, I'd like to talk a little bit about continuous disclosure obligations. It's certainly an area that keeps company directors up at night. Do you see this as a big win for company directors when it comes to continuous disclosure obligations?
Well, look, this is a big win for Mr. Forrest and Fortescue, but it's not really a win at all for company directors. What the case shows is, or illustrates, is the frustration that company directors are having with the law in this area.
Yeah.
Because after 8 years of litigation, the High Court has said that the announcements properly and correctly summarised the contracts.
Yeah.
After 8 years of litigation, it's taken Mr. Forrest and Fortescue to get to the High Court to get a proper commercial analysis of the fact situation. The High Court roundly criticised the ASIC in both its pleadings and its conduct of the case. In relation to its pleadings, it said that there were hundreds, if not thousands, of different combinations of allegations. And on that basis, the High Court said that the ASIC had not properly lived up to its obligation to clearly and distinctly state the case against Mr. Forrest and Fortescue.
Yeah. Well, looking then at continuous disclosure and implications, were there actually any implications on continuous disclosure? Unfortunately,
I've got to report that this case or the High Court decision is not relevant to the issue of continuous disclosure because the High Court dealt with the whole issue on the basis of the announcement not being misleading and deceptive. Therefore, it didn't have to consider any other issues.
Well, do you see this as a big loss for ASIC, and what's been their response?
Well, it is a big loss for ASIC, and they are going to consider the implications of this case together with the ASX. They haven't formally responded, but they issued a press release saying that they were going to consider the implications with the ASIC. They issued that on the 2nd of October. So we wait with interest what their response is going to be.
And just finally, obviously continuous disclosure is a difficult area for directors, as we've said. Do you think we're likely to see some further guidance perhaps in this area?
Yeah, I think we will. In April this year, the ASX, the Australian Stock Exchange, were going to issue a revised draft of their Guidance Note 8,
yep,
which deals with continuous disclosure. They were persuaded by the ASIC to delay the issue of that revised draft until the Fortescue decision was decided. The High Court came out with its decision. Now that the High Court has come out with the decision, I'm hoping that we'll see a draft of that revised statement shortly for public comment. Because I think directors sorely need some guidance on how to properly interpret these provisions.
Yeah, they certainly do. Jeff, thank you so much for your insights today.
Pleasure.
And viewers, thank you for joining us as well. We hope you can join us next week for our legal brief.